Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 147 of our podcast. Thank you for listening, supporting me for the last 1.5 years. I'm only 3 away from the episode 150, so we're very close to episode 200 as we continue every week. So you know that I do quite a bit of litigation. If you have listened to me, for a while now. In fact, this is my 21st year in practice. I'm very proud of that. I've helped thousands of clients over the last 21 years. And I want to talk today, obviously, about litigation, but I want to talk today about how businesses accidentally create losses. Can you stumble your way into a lawsuit inadvertently or, without really trying? And so I want to talk to you about that and how to avoid those mistakes. Pretty much most lawsuits are avoidable. And I'm talking here about the business litigation context or business disputes. There are many other lawsuits out there that are unavoidable, but I want to talk from the context of the space that I work in, which is business litigation. A lot of them are avoidable. And I want to talk to you about that. And some of the issues that I see here, I just give you kind of an overview of why these lawsuits take place. There's a lot of miscommunication sometimes between the parties. There's assumptions that they take place. There's poor documentation or poor contracts, and we'll talk about that in a few minutes. And there's also perhaps an emotional reaction to something that occurred. And there's also ignoring problems over time that can lead to a legal dispute. If you're in business, your goal should be to stay away from a legal dispute at all costs. If you can avoid that, try to avoid it. Simply because when you get into a legal dispute, I'm talking where lawyers are involved, that's going to take you away from your business, that's going to distract you, and that's going to cost you money. And none of those three things are good for your business. When you're running your business, you want to be focused. You don't want to be distracted. You don't want to spend money and things that you were not planning on, like a lawsuit. So let's talk about that. A lot of things that lawsuits begin with small items. They begin with perhaps an email that was sent by someone, or perhaps a term of an agreement that was not fulfilled, and they start in a small scale and then they escalate. So let's talk a little bit more about contracts in this case. And the contracts in everything, for the most part, and when you talk about business litigation, stems for some type of agreement that was apparently breached, whether it's a verbal agreement or there was a contract involved that was not followed. So, when somebody calls me in my office and say, somebody breached the contract, I want to say I need to look at the document first. So there's always for the most part, there's some type of document that you can look at and follow to determine really what happened. So one of the contracts that I see that lead to litigation, and when you have contracts that have undefined terms. And for instance, you may have a contract to remodel your kitchen, and but there are no terms there about how long will that kitchen, how long it's going to take for it to be replaced. There's not a provision there for materials. There's very vague provisions that later on, when the homeowner looks at that, I said, well, I thought you were going to get this material. You're going to get quartz for my cat, I know my wife is going to kill me when I talk about kitchen remodeling. So but anyway, you may have the material that you're expecting quartz, but they put marble, for example, in the countertops. So so you want to make sure the contracts are well defined when you're looking at avoiding litigation. Unclear payment terms is another one that I see often. Is one people make agreements, and I see that a lot with social media marketing or some type of software development. They're just undefined payment terms as to when the payments will be due, and there's kind of an informality uh, with that. So the definition of payment terms is very key because then that defines the expectations. Uh, when there are no deadlines in contracts, and you'll be surprised how many contracts have no deadlines, uh, and that's important to have it there. There's no termination language. When the contract is going to expire, it's going to be a contract for 1 year. It's going to be a contract for uh, renewable. It's going to be for an indefinite period of time. There's no termination date. This one is kind of my favorite. When you have a contract, and then you have when people make verbal side agreements, and I see that in commercial leases where you don't have when you have an individual landlord that owns perhaps a small strip mall, but you don't have a management company handling that, and there's a familiarity with the owner of the strip mall, and you have a situation that's your business is paying late. Instead of paying on the first of the month, they're paying on the 10th of the month, and the owner is accepting those payments, is taking accepting those payments, and he's not going. The contract states that he's entitled to collect a late fee, say of 10% of the of the payment. So say if it's a $2,000 lease per month, so he's entitled to $200 per month if you're paying late. But he's not collecting; he's accepting the check, putting the depositing the check, and not a problem because the landlord said, "Don't worry, it's fine. I'll go ahead and accept that." Okay, but there's an issue with that. So you go 3 years paying late because that's where your cash flow happens to fall in a certain way that when you have your rent payment for that lease falls sometime, in the 10th of the month as opposed to the first of the month. The landlord didn't say anything. The landlord went ahead, went along with it, and collected the payments. Then you have a situation where the landlord is about to retire, sells the business. Eventually, those business will be sold, will be transferred to someone. So the new company coming in, say it's a management company, begins to audit all those rent payments and finds out that for the last 3 years, you have paid late your rent. And the landlord did not collect those $200 per month that you were late. Okay. Now you get a bill for that past due rent. And you say, well, the landlord made this agreement with me. He was fine getting those payments. You come to my office and I say, let me take a look at the lease. The lease states, yes, he's entitled to collect 10% of the late payment, and he didn't collect. The problem is, my question would be, do you have an amendment to that lease which would entitle you to pay the lease at a different time? The answer is no. So do you have a letter from the landlord agreeing to change the terms of the lease or waiving the late fee for paying late? No. Do you have a letter from the landlord forgiving those past due those late fees? No. So the new owner in this case will be entitled to collect those fees, will be entitled to collect those late fees that you didn't pay, and even though you relied on that side deal you made with the landlord, he's retired, sold the business, he doesn't care. So I see that often when people make side deals, even though there's a contract provision that says otherwise. And especially in real estate contract, dealing with leases, purchases, you have to have it in writing. I also see it often when buy-sell agreements, when people are buying businesses And an example would be that for whatever reason, there's a specific provision when people take loans that everything is accounted for. This is the purchase price, this is the down payment, this is how much the seller is going to receive at the closing. And I've seen that with SBA loans because they're very restricted. They want to make sure that the landlord, that the buyer has the proper funds to be able to run that business. So in this example, you have a situation where the seller and the buyer made a different deal. So they say he was going to buy the business for $300,000, okay, and that's the purchase price. That's what the SBA approved, and you got to put 10% down, $30,000. You go ahead and finance finance the rest, $240,000. No, $270,000. See, that's why I don't do math. Okay. And you have different expenses. You have the broker's fee, attorney's fees. Everything's laid out in the closing statement. But the seller wants more money. So the seller and the buyer made this side deal that will pay him an extra $25,000 on the side as the purchase price, quote unquote. So he's really paying $325,000, but on the paper, it looks like he only is paying $300,000. And that's the only way the seller would sell the business. Okay. Now, the buyer goes out and asks me, do you have to pay that money? And do you have that in writing? Of course, you already know my question if you've been listening to me for a while. Do you have it in writing? No. And I say, is that on the closing statement? No. Is that on the purchase price? No. So you cannot make side deals like that. That is not an enforceable contract. And the seller is upset because he wanted that money, but you're not supposed to do that in the first place because you're representing that this is all that is owed to you. So I see that often, and then the seller perhaps wants to sue, sends letters. It's not going to go anywhere. Okay, so making signed deals is just not a good idea, especially verbal side agreements. I also I'm seeing more often now when somebody tells me, I need to review something. It's a friendly agreement. It's somebody that I know. I don't want to keep it complicated. It is a friendly agreement, a simple agreement. I see that often. And I said, well, let me take a look at it. That friendly, simple agreement has void of a lot of different provision they should have to protect his interest, the client's interest. What happens is that when people begin to do business with friends, they seem to believe that provisions should not be included there because people might be offended. That is the wrong approach. In fact, all those provisions should be there to protect your interest, and your friend should also get his own lawyer to protect his interest. You're doing a business transaction, and it has to be a little bit separation from the friendship to what you're trying to accomplish. And in fact, the more provisions you have there protecting your interest, the better it is for both sides. And that is my opinion, because it keeps things clear and you have less ambiguity as to what the terms are. But if somebody does business, should not be offended. There are terms there that is protecting you because there's an exchange of money, there's some obligations. But I see that people seem to have a more casual approach to contracting when there's people that they know. And that's human nature. Nobody is intending this to do anything wrong. It's just simply people feel that, well, we just don't need that dispute resolution procedure. We're never going to sue each other. You enter into a contract. There's always that possibility of a legal dispute or a disagreement if indeed you enter into a contract. So why not include a proper dispute resolution procedure in the event that there's a legal dispute that requires lawyers to get involved. Okay, just to give you an example. So if your contract leaves important terms open to interpretation, you're creating a potential legal risk. So it's important for you to remember that. It's important contract is clear, that are easy to read, easy to understand. You know, my rule, if you do not understand the contract, don't sign it. Have somebody help you interpret the contract. So that way you know what you're signing. Uh, Another item that can create a lawsuit, this will be number three, bad communication between the parties. That includes an angry email or text, uh, promises made casually outside of the contract, uh, employees making promises that they're not authorized to do on your behalf as a business owner. So it's important that when you have employees work, dealing with the customers, that they understand the parameters of how much they can promise to the customer within their scope of responsibility and authority. That they don't exceed that. When you say a promise will take care of this, don't worry. Uh, People will can construe that as a contract. So you got to be careful the presentations you make to somebody, especially in business. Please remember that any email you send out to someone could be end up in litigation. Any email or text message that you send to a customer, to another party, uh, that can end up in some type of legal dispute. So you got to be careful what you say in an email, what you say in a text message, uh, because it can end up in some type of evidence in litigation or a deposition. And sometimes people say things in text and messages that they wish they didn't write. So just be careful with that. Okay. Social media posts, reviews. If, people can be sued for defamation, for libel, for writing defamatory statements on social media, writing, saying statements that can be construed as defamatory. So just be careful with that. And you got to assume that every written communication, especially in business, could be utilized in future litigation. Poor documentation is another one that can lead to a lawsuit accidentally. And this goes back to contract. All roads lead to contracts, as I'm talking to you today. I've seen contracts that are sent to me that are not signed, that are signed by one party. People buying businesses, and also there's documentation that is missing. Uh, I just had the other day that somebody bought a franchise. They, right now they want to get out of that business. They bought this business from somebody else's franchise. They're operating the business, and they come to find out that they're not in the lease. That the client is paying the prior owner of that business for the lease, and then this prior owner is paying the landlord. So the new business owner, the buyer, was never added to that lease, or the lease was never transferred to her. So there's an issue there of poor documentation, because that person cannot be running that business in that location if she does not have a lease. Okay. Then the documents that I got were not signed properly. There were, I was surprised. It must have been a small franchise, because usually I see franchise documents, everything is proper, everything is correct. There's really no mistakes, but I see this particular case, I saw documents that were not properly completed, which could lead to litigation as well, depending how things go. Uh, when you have situations that are change orders, and you see that in software, you see that in And when you're doing ads in the marketing or doing some type of print work or web design work or software development work, that you begin with this idea, but then uh, there's a change along the way, but that change order was not documented. Uh, that new things are added to that additional scope of work, but they're never reflected in a change order. And then the developer does all this work, and when the person sends the bill to the client does not want to pay the additional work that was done. And the client perceives that whatever she asked for that additional work that was included in the original price and the original scope of work. So when I asked, is there a change order to that additional scope of work? No, because we had a relationship. I said I will do it. Do you have an email or text saying there's going to be this additional amount for the additional work? No. I just assumed that she would know that would be extra. So you cannot make assumptions like that, especially with doing custom work that changes over time or could change depending on the circumstance. So you begin with an initial scope of work, and if there's a change along the way, say, great, I can do that for you, but it's going to be X number of dollars more. Do you want to do it? Yes or no? It's one of the two answers. The answer is yes. Okay, great. I'm going to send you this bill, change order. I need you to sign it for me. Okay, and I'll send you an invoice for that change order. So keeping things clear is very important, especially dealing with contracting. Um, Not all meetings can be have to be documented, but some meetings are. So it's important that when you're dealing with a customer, if it's something routine, obviously on a day-to-day basis, you don't have to worry about that. But if it's something that changes the course of the work or changes uh, or perhaps a beginning of a dispute, it's important to clarify that discussion. The way to document that is after you have that meeting, obviously one way is recorded with everyone's permission. That's very clear. Uh, the second way you can do it is that after the meeting, is send an email, say, listen, per our discussion we had today, this is what we agreed to do. This is what happened. I just want to send you an email. Please confirm that my understanding was correct. You get it back, then you have the documentation of that particular meeting or communication. Um, Another area that leads to litigation is ignoring problems early. You know, that or ignoring problems. Problems escalate, and sometimes it's good to tackle them when they happen. But when you have a situation where you ignore them, you might have an issue. And I'll give you an example. There's this client of mine that she sold some money from the employer. The employer was, she did her work, and the employer, for some reason, is not paying her uh, also like 2 weeks of salary. And there are text messages between them, there's communication between them, but she's entitled to that money. Now, this business owner, for procrastinating and not handling that, very likely uh, could end up paying even more if there's a wage and hour type of lawsuit against her for not paying salary or wages to the employee that are rightfully owed. Um, so that's just an example of not handling things properly. And the business owner herself could be personally liable for not paying those fees, not paying the salary. Uh, Demand letters that are ignored. This happens very often. When you receive a demand letter from an attorney, uh, and it is ignored. And I've said this before: if you get a demand letter from an attorney, it's important not to ignore it. You know, and this letter is intimidating. I'm not going to tell you that you're going to get a letter, you're going to be so happy that you received it. No, there's some things that are not going to you're not going to like because they're making allegations and accusations against you about what you did or did not do, which led to some type of monetary injury or some type of injury they're entitled to relief. They're demanding something from you, and clearly it's unnerving. And they give you sometimes 10 days to reply or less than that. So, in a case like that, it's important to you can acknowledge the letter to the attorney, say, "Listen, I received this letter. I'm about to give me some time so I can get a lawyer, and the lawyer will respond back to you." You can acknowledge it, and at that point, you need to retain a counsel immediately for the attorney to handle it. And if you heard me say this before to you, that if there's an attorney on the other side in the dispute, it's good to have you have an attorney on your side assisting you as well. You're already outmatched if you have an attorney on the other side, you don't have one. So it's important that those letters don't get ignored, and then the attorney that you hire handle that whatever dispute there is in that letter, have that attorney handle it on your behalf. It's a much better approach than handling yourself and negotiating with the attorney. And I've seen this. I mean, I've seen that people get demand letters and they start giving out bank statements, they start giving out documents, they start giving text messages, and then they come to me and say, "Hey, I received this letter," and then I gave them all this information. I was negotiating something directly. We just didn't come to terms, and here we are. And I said, "Well, why do you provide all this documentation to this attorney in the first place?" I said, "Well, he asked for it." I said, "Great, but you didn't have to provide that documentation in the first place. Now he has more evidence against you." So there are things that an attorney can protect you from, and really protecting you from yourself. Okay, so if you get some type of demand letter, do not negotiate directly with the attorney. Get an attorney yourself and have the attorney handle it for you. You're going to be in a much better position that you do it directly with the attorney. And partnership issues, I want to touch upon that as well for a few minutes. And you heard me talk about partnership disputes, and that's a big part of my practice. I deal with a lot of partnership disputes. I deal with fraud claims as well. Uh, People buying and selling businesses, and with partnership disputes, some of the common themes that I see happening that lead to litigation is the absence of an operating agreement or bylaws, which every business owner that has a partner should have. Number two, there are undefined areas of responsibility and authority between the partners, which lead to overlaps or stepping into each other's toes, so to speak, when they begin to do their work. Poor management and poor communication. The one partner spending money or using the business for personal expenses. One partner carrying more of the load, the workload, than the other partner. That leads to resentment, which leads to somebody saying, "I'm out. You got to buy me out," and that kind of leads to a potential litigation. So, I've done podcasts strictly on partnership disputes, but this is one of those that can lead to litigation if they're not properly handled, because it starts with a small disagreement, then somebody says something, and then the partners begin not to talk, and then begin to usurp the other's authority, telling the employees, "I'm the business owner. I'm the owner of the business. You got to report to me. I'm the one that's in charge here. The other business owner says, no, it is me. So putting the employees in a difficult situation of who to follow, who to take orders from. So that will decrease morale. Employees may start leaving. Uh, and that could lead to a potential litigation as well. So the key, or how to solve that, how to avoid that, the business owner should have regular monthly meetings at least monthly, if not weekly, whatever their rhythm is, whatever their time frame is. They should have regular meetings to discuss the business or any issues they might have. Number two, they need to have an operating agreement or bylaws to make sure, and that actually the bylaws or operating agreement that actually have details on what the rules and responsibilities of those owners are, what are the levels of authority are, not just a blanket template that we get from the web and download it here, sign it. It doesn't have anything about what they're supposed to do, what are the limits of authority, what are the spending limits, who can enter into contracts and for how much. That should be spelled out in the contract. What expenses can be paid out of the business, which ones cannot. That should be spelled out in the contract. Who's going to be responsible for day-to-day operations? Who's going to be responsible for marketing, for example, or sales? Who can hire or fire if it's unanimous? What decisions will be made by unanimous consent? Which decisions can either partner make unilaterally? Those decisions should be spelled out in the operating agreement, because that will avoid problems. If there's a dispute that we cannot talk among ourselves, how do we solve that? Do we go straight to court, or there's this mechanism in place before that that we can use? And I recommend mediation and in partnerships as a first step approach, with certain exceptions, of course. But let's talk generally speaking for a regular disagreement or something that the business owners need a third party to help them. A mediator might be a potential. Mediation might be a way to resolve that confidentially, smooth things out, and move on. So it's just an option as well. So just, I want to apply common sense when looking at these issues. Okay. Litigation is very expensive. It's very costly. It is emotionally draining as well. You as a business owner don't want to get involved in any type of litigation. Okay. If you do, then get the proper representation to help you so that way it can be handled properly. But if you can avoid it, by all means avoid it, and just apply common sense with these issues. If another another example that I give you before I close is, say somebody, falls in your premises. You have a business that deals with the public. They come into your business and somebody has some type of fall. It's important to contact your carrier, let the carrier know, okay, that this happened. Have a procedure in place. Just don't ignore the problem. So there are many different things you can do to avoid lawsuits. More importantly, apply common sense. And if you have any questions about something that could lead to a lawsuit, just call your attorney. So listen, I have the situation. I want to run it by you. Okay, it might be nothing. It might be something. How can I prevent this from happening? Proper communications, clear contracts, clear invoicing that avoids potential litigation. Hope you enjoyed this episode. Again, hope you're not involved in any type of litigation. I hope this helped you kind of have that awareness of how to avoid them. If you have any questions about this episode, any of the episodes that I've done in the past, you can email me rich@richsierra.com. Again, it's rich@richsierra.com. My phone number is 866-842-5202. If you want to, if you have any legal questions, legal issues, you want to look at our law firm for potential services, my website is Florida Small Business Legal Center.com. Again, it's Florida Small Business Legal Center.com. If you want to watch this podcast, we have it on video as well on our YouTube channel. It's youtube.com/@RichardSierra. We're also on Facebook at FSB Legal, Instagram as well. forget you want to check out my book, Business SOS, 8 Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.